Hello my dear friends, welcome back to my YouTube channel. Myself I am Lokus Jogi. I have completed MSc in Agriculture Seed Science and Technology, Specialization Seed Science and Technology from HNBGU Central University Srinagar, Uttarakhand in 2020. I have got 52 rank in PhD program Seed Science and Technology from Indian Council of Agricultural Research ICAR All India Entrance Examination for admission in 2021. Today I am going to tell about the India's Plant Variety Protection and Farmers' Rights Act. The Indian Parliament has finally passed the Plant Variety Protection and Farmers' Rights Bill. India has now for the very first time put in place a law to grant place breeder right on new varieties of seeds. The law also grants farmer rights. These have been included in the legislation as a result of the determined and sustained campaign by NGO spearheaded by the Gene Campaigns. Gene Campaign is position right from the start was that if the status quo had to be changed and India had to grant plant breeder rights, our legislation would have to grant a strong farmer rights at the same time. We maintained that plant back rights, example the right to save seed from the harvest to sow the next crop, were no right, only expansions breeder under UPOV granted. Such expansions referred to as farmer privilege. We instituted that Indian law had to grant right, not provide exemptions to its farmers. Our key demand was for the farmer to retain the right to sell seed the other farmers. Even if the variety was protected by farmer right, this right to sell seed is crucial to maintaining the livelihood basis of the farming community and the nation self-reliance in agriculture. The clauses of the right to sell seed was the major one of the contentions to the very end to legislative process. The pivotal importance of the farmer having the right to sell seed has to be seen in the context of seed production in India, where the farming community is the largest seed producer, providing about 87% of the country's annual requirements. Denying of the farmer the right to sell seed would displace the farming community as the country's major seed provider. Their only replacement would be the life science corporations, since budget could have seriously weakened the capacity and output of the other major player, the public research institutions, and any development that would give multinational corporations a significant share in seed production in India was unacceptable to civil society groups. Farmer rights. In section 39, fourth of the chapter on farmer rights, the right to seed, even protected seed, has finally even provided. The farmer shall be demanded to be entitled to save, use, sow, resow, exchange, share, or sell his farm produce, including seed of a variety protected under this act, in the same manner as he was entitled before the coming into force of this act. However, the farmer is not entitled of to sell branded seed of variety protected under this act. Editors intellects other kind of farmer rights. The act acknowledges the role of rural communities as contributors of landraces and farmer varieties in the breeding of new plant varieties. Breeders wanting to use farmers varieties for creating essentially derived varieties cannot do so without the express permission of the farmer. Anyone can register a community's claims and have it duly recorded at the notified center. If the claims is found to be genuine and share to profit made from the new variety has to go into a national gene fund. Expansions from farm fee. Further protecting farm from the new set of provisions being put the place in new act stipulates that farm wishing to examine documents and paper or issue copies of rule and decisions made by the various authorities will be expected from paying any fee. Disclosures explicit and detailed disclosure in the passport data about the percentage of new variety is required if concealment is detected in the passport data. The breeder certificate stands to be cancelled. No terminator technology. Breeder must to submit an affidavit that their variety does not contain a gene use restricting technology or terminator technology. Protection against innocent infringement. Rightly assuming that a farmer may be economically infringing breeder right since the will not be used to be the new situation. The law provided for protection from prosecutions for innocent infringement. Good clauses that could be better. Benefit sharing. The provision for payment for use of farmer varieties is welcome, but modalities of implementing benefit sharing must be made simpler and less bureaucratic. The revenues earned should only be available for use farming communities in the way that the decided. Protection against bad seed. The clauses protecting the farmer from spurious seed leaves too much to the discretion of the authority. There should be specific guidelines such as that compensations should amount to at least twice the protected harvest value of the crop. In addition to a sale term should be provided for repeated offense. Right of breeder and researchers. Breeder rights are fully protected by the legislation on registration. The breeder that has complete right of commercializations for the registered variety. These include the right to produce, sell, market, distribute, import and export the registered variety. Penalties for infringing breeder rights. Violations of a breeder right can apply to the variety itself as well to its packaging. Penalties can range from 50,000 to 10 lakh as well and jail the raggings from the 3 months and 2 years depending on the severity of damage cases. For repeated offence, fine can go up to 20 lakh and the jail terms to 3 years. The new law has provisions for researcher rights which allow scientists and breeder for access to registered variety for research. To registered variety can also be used for the purpose of creating new varieties. Finally, flexibility is credited only when the registered variety need to be used repeatedly as a parental line for commercial production of another variety. Public protection of public interest. The legislation include public interest clauses like exclusions of creation certain varieties from protection and the grant of compulsory licensing to safeguard public interest. Certain varieties may not be registered if it is felt that provision of commercial exploitations of such variety it is necessary to protect order or public morality or human, animal and plant life and health or to avoid serious prejudice to the environment. Compulsory licensing. The grant of a compulsory license is provided for the it is found that the responsible requirements of the public for seed have not been satisfied. Satisfied are that the seed of variety is not available to the public at the responsible price that the breeder may be file an oppositions button should the change be well to the breeder can be ordered to grant a compulsory licensing under certain conditions including the payment of a reasonable license fee. However, no compulsory licensing will be awarded if the breeder can be demonstrated responsible grounds for his inability to produce the seed. After plant variety legislation, what next? Now that we have enacted of a plant variety protection and farmer rights law, the next step will be to decided through which international platform India will interact with other nations. At present, the only international platform is a UPOV, as a Western platform regulating plant breeder rights for the industrial nations and controlled by the life science corporations. India should be India should not jail UPOV. Gene compassions opposes India joining UPOV because UPOV does not address our need and because it is its working is totally aligned to the conditions of agriculture prevailing in the countries of the south. We believe that developing countries must create their own platform which will be grant farmer rights distinct from breeder right and be geared to be work toward food and nutritional security. In our countries, there is no concept of farmer right in the UPOV system. Right are granted only to the breeder, which in today context means the seed companies. UPOV law are formulated by industrial, not agricultural economics. In these countries, the farming community is by and large rich and constitutes from 2 to 5% of the population. These countries do not have the large number of small and marginal farmers that we do. COFVF developing countries alternative to UPOV. Gene compassions along with the Center for Environment and Agriculture Development has draft, drafted an alternative treaty to UPOV to provide of a form for developing countries in implement their farmer and breeder right. The treaty, the treaty is called the Convention of Farmer and Breeder (COFV) for short. COFV reflect developing countries' strength and vulnerabilities and seek to secure their interests in agriculture policy making. The UNDP Human Development Report 1 1999 commended COFAB as a strong and coordinated international proposal which offer developing countries an alternative with the two following European legislation by focusing legislation on need to protect farmer right to save and reuse seed and fulfill the food and nutritional security goals of their people. Gene Campaign's purpose in drafting an alternative to UPOV was the provided the basis for discussions on what kind of non-UPOV platform developing countries should have. Once concessions emerged, their comprehensive analysis and critique among developing countries will not take long to come up with a minimum operational framework with which to start. Environment related trade implications. Although WTO membership will provided opportunity to increase export and many sectors are likely to benefit from this, some sector will face challenge from increasingly stringent environmental standard and various volunteer measures. Textile, toys, leather, other light industry product and many agricultural goods are most likely encounter environmental means from western countries where consumers are more environmentally conscious. Meanwhile, if imports of forest and food product grow, the chance to bring in line invasive species will also increase in order to protect human, plant and animals health and the environment. China needs to strengthen its sanitary and phytosanitary regulatory regime. A high degree of policy preparedness will be necessary to enhance policy and administrative capacity to address the issue above. First, it is imperative for China to adjust its environmental policy to address the consequences brought about the structural change due to WTO membership, as change in the economic will regularly define the environmental agenda more. All through assessment of the environmental sequence of World Trade Organizations associations should be undertaken to ensure that the necessary policies are in place to address environmental challenge of trade liberalizations and to promote sustainable trade. Policy guidance is needed to seize the opportunity that China WTO assistance provides to address environmental problems through restricting WTO membership may also bring excellent opportunity for China to gradually upgrade its environmental management system and standards. Second, China need to make efforts to comply with its WTO obligations. WTO rules will limit the options available to public authorities to respond to change in environmental threats since any measures that are adopted must be both non-discriminatory and comply with the transparency provisions and various World Trade Organization agreements to increase predictability and transparency. China must codify existing practice into written law and regulations. Third, China must be integrated environment contents into relevant trade policies and address challenges both at home and abroad. Close operations will be necessary among departments responsible for the trade, environment, and technical standard and other. Green measures for foreign countries should be studied to help enterprises meet to green challenging in international market. Fourth, there is need to support Chinese officials in acquiring in-depth understanding of WTO World Trade Organization rules related to trade and the environment and the policy issues involved. This will help them participate in future WTO negotiations. Assisted the adoption of the domestic rules consistent with WTO rules addressing trade and environmental issues as well as resolve disputes within China jurisdictions at bilateral level under WTO auspices. Finally, China's associations will be bring change in the balance of power between developed and developing countries in the WTO. As a participant in WTO decisions making and negotiations, China need to develop a forward-looking and positive in order to play an active role in promoting both trade liberalizations and sustainable development. Thanks.